So in Texas, most people are going to be looking to get a divorce under a no-fault divorce. However, there are other reasons people can get a divorce. So some of the grounds that you could see in an at-fault divorce would be like adultery or cruelty. Cruelty often includes domestic violence as well. Other factors sometimes would come up as abandonment. So whether or not you're going to have a divorce where there were a no-fault divorce or whether there's an at-fault divorce, that could be a factor in what the court considers and how to apportion the resources or the community property of the estate. However, whether it's a at-fault divorce or a no-fault divorce, either way, the court's going to grant a divorce if one of the parties is wanting to ask for a divorce. Texas is a community property state. So community property is all of the property that was acquired during the marriage is normally going to be considered community property. The courts are going to look to divide that. Normally, they're going to start with the presumption that everything should be divided 50-50 or try to make it as close to 50-50 as possible. However, there's other factors that can come into play. If one party makes more money than the other party, if there was reasons for the divorce, one person's more at fault than the other person. One person's going to have more expenses than the other person, like for example, is raising kids. All those are factors that can come into play that can give a different division than a 50-50 division. Typically what would happen if you're going through a divorce in Texas, we would total up the assets of the community estate, which would be all of the community property that you have and all of the community property that your spouse has. And then we would also take into account any debts that occurred during the marriage, and we would put that into like a spreadsheet. And our goal on a normal divorce is going to try to move both columns to where both columns essentially have 50% of the community estate. Because of the factors that we mentioned before, sometimes you can see up to 60% in one direction, 40% the other direction, and in some extreme cases, maybe 70% for one party to 30% for another party. There's two types of alimony in Texas. There's temporary alimony, and then there's alimony that would occur after the divorce process is finalized. Alimony after the divorce is finalized is disfavored in the state of Texas. What the court would rather do is give the party who needs alimony a disproportionate share of the community estate. However, sometimes that you have a situation where there's not much money in the community estate. Say one party drained all of the assets, or one party makes way more money than the other party. Those are factors where you could see alimony on a final divorce. Temporary alimony is different. When a divorce is filed, within the first month or so, you're going to go to court and you're going to have what's called temporary orders. Temporary orders are what's going to be in place until you can get to your final trial date. Your final trial date's probably not going to be for like a year or so. So during that time, the court's going to want to make sure everybody's needs are being met. All the bills are getting paid. Presumably one spouse is going to need to move out of the house. So we got to make sure the mortgage is getting paid. We got to make sure the car payments are getting paid. Nobody's going to get rich in this situation, but the court's going to make sure as long as there's money available that people are going to be taken care of. So the rules are not as tight on temporary alimony. Temporary alimony is much more likely to happen than final alimony. In Texas, we divide custody into two parts, legal and physical. Whenever anybody talks about custody, they're normally thinking in terms of the physical custody, who's going to have the child. But the first thing we look at as lawyers in Texas is the legal custody. And this is over who has legal rights to do certain things for the kids. We call that conservatorship. And in Texas, it's presumed that both parties should be joint managing conservators. So both parties should have joint custody. But that's going to give both parties legal rights to the kids, that they can go take the kids to the doctor, that they can sign documents for the child, they can make certain decisions for the child that come with the legal rights of being a parent. And we divide those up in different ways. Three of those rights that are often contested, we call them the heads, meds, and eds. The heads is the right to make decisions about psychiatric and psychological. Meds is the right to make decisions about non-emergency invasive medical decisions. And education and educational decisions. Any parent's always going to have the right in an emergency to go take their kid to the doctor and do whatever they want to do. And any parent's always going to have a right to take their kid to just go see a doctor. But if there's going to be an invasive procedure, something where you're cutting into the skin, have your tonsils removed or have a surgery or anything like that, that is going to be something that falls under that exception where it's a non-emergency invasive procedure. And the court's going to normally want to have one person be in charge of that because they don't want to have something where it's just a disagreement and nothing can get done. So the court is probably going to give somebody that exclusive right. They're going to give somebody the exclusive right to psychiatric and psychological, and they're going to give somebody the exclusive right to make educational decisions. That's the legal side of things. When you're talking about physical custody, that's normally where the child is going to live Monday through Friday with that parent. And then the other parent typically is going to have what's called the standard possession order, where they're going to have the child on the first, third, and fifth weekends, and then Thursdays of every week. I can vary, but that's normally what the courts are going to do in a default situation. A lot of times people will come to us and they'll say, I want sole custody. Well, when they say I want sole custody, what they normally mean is they want the right to designate the primary residence of the child. Sole custody goes back to the legal rights. And in those rights, if you do have a situation where it's sole custody, normally you're going to have a problematic parent involved. There's going to be domestic violence, drug abuse, something to where the courts are going to say, we're not comfortable with this parent having joint conservatorship rights. Going through a divorce is often going to be one of the most trying times in your life. Not only are you going to be dividing up everything that you own, everything that you've saved, everything that you worked for, you're also going to be having to share what's most important to you in your life, your child. There's so many different complexities that go into this. We'd be happy to give you a consultation and then walk you through the process to help get you through this and make sure that whatever happens in your divorce, that as much of your assets can be protected are protected, and more so than that, that as much of your relationship with your child can be protected, and that you maintain a strong presence in your children's life. Give us a call at the Bayley Law Firm. We'd be happy to help you out.